Morning.
There we are. I am in.
You all right?
Yeah. I've just messaged it. Did you send the link to Alistair as well as me?
Yes, I did. Yeah.
Yeah, lovely.
Good. Let me see. Maybe today. I don't know if you can get access to the slides, but don't worry. You can nudge me to do it. If not, oh, here we go. Thanks, but I think there's only me so far. Am I in the right place? Yes, Joel, you are in the right place.
Yeah, I was. I hadn't pressed the connect button. I realised.
Not to worry.
No.
What I'm going to do when we do start is turn all my emails off, just because it ends up dinging through the webinar. I just heard the dog squeaking a squeaky toy, so I'm going to go and take that off him and shut the door downstairs. So won't be 1 minute.
All right.
It's always chaos at my house.
Yeah.
I looked this morning and we've had another 4 people sign up as well.
Good.
No, yeah, we're on 74.
Alistair's just messaged to say that he hasn't got the dial-in details.
Sent to him a minute ago. I'll do it again. So Alistair Duncan, send invitation email. Let's see if I can send him the link. I'll send it to him in an email now as well. I've just sent him the exact same thing that I've sent you.
Yeah.
I'm sending the link on top as well. Joel, I am still waiting for dial-in details.
Yeah, I've logged out of Microsoft Teams and everything this morning just to make sure that I've got nothing that's going to pop up and interrupt.
Yeah, I'm going to stay in my emails just until Alistair gets in.
Yeah.
So put this over here. God, I've got 2 screens and I don't know, for some reason at the minute it sticks, you know, when I'm trying to swap screens. So
yeah.
Let me make sure I've got the right email address for him. Alistair, options. Oh, in fact, I've just sent the link to his email address anyway, so through my Outlook rather than through Webinar Geek. So he'll have that link as well.
Right.
There he is.
There we go.
Morning.
Good morning.
You're in.
Morning, Alistair.
Morning, Joel. Yes, I eventually found it in my spam folder.
Sorry about that. Do you know, I've just closed my Outlook and realised I've just deleted an email, but never mind, I can rewrite it. Restore it. How's things up there, Alistair? Are you okay?
I'm well, yes, thanks. Nice bright morning this morning.
Did you watch the rugby at the weekend?
Surprisingly, I did, and I enjoyed it very much.
No, I bet you did. Oh, you played well anyway. Right, save messages. Yes. Did you watch the rugby, Joel?
I did. I watched most of it. I missed the start because I was out with the boys. But yeah, I caught the end of it.
Oh, I'm excited.
It was a decent game. I missed all the exciting bits by the looks of it. So.
Now I'm taking some clients to England, Wales on the 26th down at Twickenham.
Yeah.
So I'm really trying to pay attention to the games this time so I can sound vaguely knowledgeable at the match. So yeah, paying attention anyway. So I will field. If you, as we mentioned before about the. When are you touching the thingies, which is absolutely fine.
Sorry, that was me. That was me. I was just playing with it, but I don't want to play with it.
No, don't bloody touch it. No, you could use just conscious people can hear us, but that's fine. We're not saying anything that we shouldn't. But yes, I will field questions, and then we can feed them back to you, both of you, at the end. So if you just mention that there's a chat box, and I'll keep a look in there.
Yeah.
There's public and private chat, to be honest.
Okay, good morning, everybody. Welcome to this morning's webinar. You've all signed up quite willingly, so this is your own fault, to a webinar entitled VAT on Disbursements and Update and Common Issues. So welcome, and we're going to start now. I think there's still a few people joining, but we'll just begin with some introductions. So I just wanted to say welcome. My name is Joel Topham. I'm a business advisory director at Sagars Accountants Limited. We are a firm that's been around for a long time. I've been here for 17 years, and throughout those 17 years, I've been working as a solicitor specialist, advising on all different areas to do with solicitors' accounts, whether that's solicitors' accounts rules or practice management issues or tax efficiencies or profit maximization strategies. I kind of cover all bases that are relevant for solicitors and their accounting records, which also means I get asked a lot of questions on VAT, and in particular on VAT on disbursements. Which is part of the reason that I'm here today. Also presenting with me is Rebecca Lander. She is the Strategic Account Manager for the TM Group. The wider TM Group is a forward-thinking technology business that is using software and data to provide more efficient, more accurate, and easier to use services for conveyancers and other property professionals. And also here is Alistair Duncan. Alistair Duncan is an indirect tax director at Anderson & Brown LLP. He has more than 30 years of experience of working with indirect taxes, focusing primarily on VAT, including 10 years working for HMRC at the start of his career, where he learned everything that he needed to know, apparently. So between us, we are going to try and talk us through all the different elements that we've got on here. You can see our lovely faces there. The agenda as we have it is that we are going to be talking about VAT on disbursements. As you can tell from the title, VAT is a complex and constantly changing tax that confuses most people, including HMRC, if we're being honest at times. We're here to provide a refresher on the key issues that impact how we treat disbursements for VAT purposes. We'll refer to case law as we go through, including the Brabner's case, which everybody is usually very familiar with. And we will try and give you some tools to help you make the right decisions in relation to how you treat your disbursements for VAT. We'd love to be able to give you a lovely fixed list of how every disbursement is treated, but that's not possible, unfortunately. But we will do our best to help you make the right decision as you're going through. We'll talk about the changes that have been brought about by the Brabner's case, and specifically how that dealt with disbursements and specifically searches. We'll look at that in the context of how it impacts not just solicitors, but also the solicitor's clients. And we'll talk about potential solutions to negate the impact on them. And then we'll finish off with just a quick look at a few other hot topics within VAT, just to keep you abreast of all those other issues that are going on in the profession. So I guess the first question that we need to sort of ask and answer is why are we still talking about VAT on disbursements? As I mentioned, I started work at Sagars back in 2004. And for many years, the VAT treatment of disbursements was just not discussed. It was largely accepted. Everybody knew where we stood within the accounts teams, with clients. But then in 2017, the case of Brabner's versus HMRC hit the headlines and shook up the status quo somewhat. And so in a little bit of time, Alistair will take us through the detail of what happened in that case. But Brabner's was supposed to set a standard that everyone could follow in some respects. And in some ways, it should have made things clearer. It was an actual case that had been tested. But 5 years down the line, we're not sure that that is the case. In the last 3 months, I've had 4 different queries from 4 different clients about how to treat certain types of disbursements in relation to their clients and their work, and not just about specific disbursements, but about the principles behind it as well. which indicates that this is still an area that causes concern to accounts teams and solicitors across the country, which is why we thought it would be a good idea to refresh ourselves on the position that we're in today. But before we get into Bravner's itself and other case law around disbursements, we should address what really is the source of confusion around VAT and disbursements, which comes from the terminology and the definitions that are applied to the term disbursement itself. Because HMRC, solicitors and their clients each have their own understanding of what a disbursement is, and these are not as harmonious as we would like them to be. So Alistair's going to start by talking to us about what disbursements means from a HMRC perspective.
Thanks, Joe. So first of all, can I just check, is everyone happy with the sound quality? That there was a message earlier saying that sound quality wasn't great. Is this any better?
Yeah, we can hear you nice and clear, Alistair.
Okie doke. So first thing I will say is that I appreciate that there's much more legal knowledge and legal expertise on the call than I can ever partake. So I'm going to be mentioning one or two principles and concepts, and I'm not trying to teach my granny to suck eggs. It's just that I'm a VAT practitioner, so I'm used to a very simple tax. VAT was introduced as the simple tax. So I'm a simple person, so I have to go back to first principles when I talk about certain things. So I will be talking about things which are obvious to you. You know, there's probably in excess of 1,000 years experience of dealing in law on the call. I'm not going to try and match that. As Joe says, the first thing we've got to realise is that when we're talking about disbursements, we're talking from a VAT point of view, we're talking about a very narrow definition that HMRC look at. And the terminology that's used across a number of sectors can be confusing in that the words disbursements, outlays, recharges are thrown in, used interchangeably. Some people use for actual disbursements will refer to outlays. Others will, when it's quite clearly a recharge or an outlay, will refer to disbursements, and it can get very confusing. So let's start by just confirming what we mean when we talk about a disbursement and what we talk about an outlay. So disbursements first. What we're looking at is a payment made on behalf of and as an agent for the customer. And the customer has provided permission for that payment to be made on their behalf. It's the customer who's receiving those goods and services, and ultimately it was their responsibility to pay for those goods and services. They knew that a third party was going to be providing that. They didn't expect that to come from their principal supplier. On any invoice, these costs are separately itemised, and it's only the exact amount that's passed on. You don't add a markup to it. You don't look to make any profit out of that. If you meet all of these conditions, from that point of view, that meets the definition of a disbursement. And from that point of view, no VAT will be due. That supply is outside the scope of VAT. On the other hand, for outlays or recharges, what we're looking at is costs that you have incurred in delivering your service to your customer. So, for example, if you have postage, if you have telephone calls, if you're traveling to a business meeting and you're recharging mileage, all of these are outlays and recharges. Again, they can be separately itemised or they can be added to the cost of the service. It doesn't matter if they're separately itemised. If they are simply a cost of providing that principal service to the customer, then they are not a disbursement for VAT purposes. And the key thing there is that the VAT that applies to that recharge or to that outlay follows the main supply. So if the main supply is standard rated, the outlays are standard rated, even if the outlays themselves didn't have VAT in the first place. So, for example, if you're recharging a train fare, you would still add VAT to that train fare because that is part of that principal supply. If the underlying supply is outside the scope, perhaps because of the place of supply rules, then any outlays and any recharges are also outside the scope. So that's the VAT definition. I'm not going to try and say, that one way or the other, how you're referring to things is wrong. But when we're talking about VAT and the VAT treatment, that is the important factor. So the next thing to look at is...
that contrasts quite significantly with what the SRA defines as a disbursement, because the SRA's definition is any costs or expenses that are paid or to be paid to a third party, save for office expenses, which, and I would look at it as being there's quite a difference in perspective in that the SRA's definition, certainly for the accounts rules purposes, is always that, well, it's a disbursement unless it's office expenses, whereas I always feel HMRC's perspective is it's a recharge unless you can prove it's a disbursement. And for VAT purposes, the kind of the effect and the way that HMRC looks at things comes from the opposite way to how you're taught as solicitors to look at disbursements and how you're taught to define it.
Yeah, certainly, very much HMRC are coming from it from the point of view of VAT is chargeable unless you can prove otherwise, rather than the default position is always that something is subject to VAT, the standard rate. You can look through the VAT Act all you like, and it never says that something is standard rated. It just says everything is standard rated unless you meet one of these. And you have the zero rate schedules, reduced rate schedules, exempt schedules, which takes things back out of VAT. And it's the same with the disbursements. It's in the scope of VAT unless you can prove and meet the condition for it being disbursement to come back out of the scope of VAT. So historically, the definition of disbursements and for VAT purposes was a bit more broadly drawn, and it was a case of if there's something that you're recharging to a client, you can treat it as a disbursement. If they know that you're getting it from someone else and you're paying it on their behalf, then you can treat it as a disbursement. Bramner's, as Joel said, very much changed that. There had been earlier case law where the idea of are you acting simply as a post box or are you receiving those services, those sorts of ideas were thought about. But Bramner's is really where things were crystallised in terms of the VAT position. And again, the important thing here is that following Bramner's, the definition of what is a disbursement as per the Law Society guidance has been narrowed very significantly. And the key factor in Bramner's is, are you using the service that you've received from that third party or that search company or legal provider? Are you using that service in providing your service on to the client, or are you just simply passing it on? The key thing for Bramner's is that was a first tier tribunal case. So the only people on which it set a precedent were the two parties in the case. It didn't apply to everyone else. It gave guidance for everyone else, but it didn't set precedent because it was only first tier tribunal. The important thing following on from that is that was the BA and Prosser case, which looked at it at a much higher court. And BA Prosser was not a VAT case. It was a case looking at whether or not there had been accidental hurt caused to an employee and whether BA were liable for that. They were proved to be liable for that. And it was a case of what are the costs that BA had to meet. And that's where the question of, are we dealing with VAT on these costs, or should VAT not have been added to these costs because they were a disbursement? And the auditor comments in BA and Prosser very much brought to the fore the fact that other than Bramner and HMRC looking at the position for them alone, this is a situation that all legal firms had to look at and consider whether or not their services or their recharges were outlays or disbursements. And broadly, there's three, possibly four scenarios or categories that we can look at in terms of costs. No, sorry, if we stick where we are for the moment. And these are third-party costs or non-statutory costs is the first one. So generally speaking, if you are buying in a service from a third party or if you're incurring a non-statutory cost, the chances are that you are receiving that as part of the service that you're going to be onward supplying. So, for example, you may receive a medical report from a doctor whereby you are then interpreting that and putting that into the advice that you're providing to your client. So you're using it in providing that end supply to the client of the legal advice that you're providing. So that's one end of the spectrum. The other end of the spectrum is client costs, and these are costs that are quite clearly the responsibility of the client, and you're just paying it on the behalf of the client. And the most obvious one for that is stamp duty. And whenever anyone talks about what is a disbursement, people just say, well, stamp duty is a disbursement, because quite clearly all that you're ever doing with stamp duty is paying that on behalf of the client. So those are the two ends of the spectrum. In the middle are statutory fees. And statutory fees are those that could either form part of your onward supply or don't form part of your onward supply. So the obvious one is and we'll look at this in a bit more detail shortly, but the obvious one is search fees, which are statutory fee, and you are using those search fees to provide that conveyancing service that's happening. So it's quite clearly forming part of that onward supply. So following Brabner, quite clearly it doesn't qualify to be a disbursement. And then there are other statutory fees, like of court fees, where it's a bit more grey as to whether or not you are actually using that in your service. If you look at it from the point of view of the client, they'll say very much, well, we're wanting the whole package, and that includes, the payment of the court fees. But from the point of view of the lawyer and solicitor, it's what are you actually doing in terms of those court fees? Are you adding value? So when you're filling out the documentation that incurs the court fees, are you adding value to that, or are you just simply putting in name, address, and telephone number and submitting a document? And if it's the latter, then it is likely that will qualify as a disbursement. If it's the former, then it probably forms part of your overall service. Again, a bit more of a grey area than certain other costs. So there we have the spectrum of costs, and you can see that the fact that we have a spectrum is why you're still getting questions 5 years after Brabner. So let's look at that if we move on to the next slide. Thanks. Let's look at that and how that looks in terms of the impact on clients. And first of all, we'll look at private individuals, non-VAT registered clients. So if they were to incur a cost themselves on which there was no VAT, and that cost was, say, £1,000, the cost to them would be £1,000. Similarly, if they were to incur a cost direct from the supplier for a service which has VAT on it, it'll be £1,000 plus VAT. So the cost then will be £1,200. So that's if they're buying it directly. Let's look at what happens if it's being bought by you and onward supplied. So if it's a disbursement and there's no VAT on that cost, the cost that's charged to the solicitor is £1,000. The cost that's recharged by the solicitor is £1,000. So there is no cost to the client there. Similarly, if it's an outlay with no VAT, and again, we're talking about VAT registered individuals here. Sorry, did I say I was talking about non-VAT registered? Sorry, I apologise. I've got my slides out of order. But right, so starting again, very quickly on the first point, if it's a VAT registered person and they're incurring the cost, whether there's VAT charge or no VAT charge, it's going to be £1,000 to them because they're going to be able to recover that VAT. So apologies for that confusion. So on the first one, £1,000 received, onward charged, the cost of the client is £1,000. On an outlay, it's £1,000 received, £1,000 plus VAT onward charged, but the VAT is recoverable. Therefore, the cost of the client remains £1,000. Similarly, if it's an outlay, it's £1,000 charged to the lawyer. The lawyer is able to recover that VAT. They onward charge that £1,000 plus VAT. And again, the VAT registered individual is able to recover that VAT. Therefore, the cost of them remains £1,000. Where you have a problem is if you have a vatable item which you're treating as a disbursement to a VAT registered business. The cost that comes into the lawyer is £1,000 plus VAT. The lawyer can't recover that VAT because they're treating it as a disbursement. It's not a cost to them. So they can't recover that VAT. So they have to recharge that cost at £1,200. Because they're recharging that as a disbursement, that means that the client receives a cost of £1,200. So they're worse off by treating that cost as a disbursement because there was VAT on it. That's why, generally speaking, historically, when there was VAT charged to a VAT registered business, you wouldn't try to treat it as a disbursement. More obviously, and we'll move on to the next slide, we've got the private individuals as being the client. And as I mentioned, it's either £1,000 where no VAT is charged or £1,200 that they incur if they are incurring that cost themselves because they're not entitled to recover that VAT. If it's a disbursement, no VAT, it's exactly the same. The cost that comes in and the cost that goes out is exactly the same, so that there's no difference for the client. Similarly, on an outlay, sorry, could you? I'll move it on my screen. Sorry. If it's a disbursement and the costs incurred are £1,000 plus VAT, again, that's not recoverable. So the cost that's recharged is £1,200. So it's exactly the same position for the client. Similarly, if it's treated as an outlay, the VAT's recoverable by the lawyer. So the onward charge is £1,000 plus VAT. So the cost of the client is £1,200. And if it's treated as an outlay, no VAT coming in, but the onward charge going out is £1,000 plus VAT. So the cost of the client is the £1,200. So the client, the non-VAT registered client, is worse off if you treat a cost on which there was no VAT as an outlay. So I mentioned earlier about a train ticket that you've got to charge VAT on. It comes in zero rated, but it goes out with VAT on it. I'll come back to this, but I'll pass on and we'll look at some real examples in relation to this. Sorry, moving on.
Thank you, Alistair. Morning, everybody. My name's Rebecca. I work for the TM Group. I just wanted to point out that my knowledge is most definitely not in VAT, so I just wanted to put that out there. But I'm reasonably well versed in searches, and the two together are a common point of confusion for solicitors. So I've put a table on the screen, which one of the services that CDS and the TM Group provide to property professionals are local authority searches. Now, I often speak with clients and their accounts teams, and there's a lot of confusion over when and where VAT needs to be added to a local authority search. So the attached table actually very clearly explains this. So I'll walk through briefly the differences, or the similarities, I should say, between an official local or a regulated search on the next screen. But firstly, just to explain the VAT differences. So the local land charges element is not VATable because there's two parts to a local authority search, the LLC 1 and the Con 29. So the LLC element is not VATable, whereas the Con 29R section is. Now, with an official search, this therefore means the solicitor needs to add a further 20% VAT on the LLC 1 element when charging clients to searches. However, the regulated counterpart, because this is completed by a search provider, they add VAT, and that therefore means there is no further liability for a solicitor. So for your accounts teams, for those firms using regulated searches, their accounts teams don't have to then mess around with adding VAT to just the LLC 1 element of a search pack, because all the VAT has been settled by the search provider. Now, Alistair and Joel, can you just confirm that everything I've said is completely correct? I know we've kind of spoken about it before, but I don't want to say something incorrect.
No, that's correct. And again, we'll confirm that in my next slide. But yeah. What you've said there is correct.
Perfect. I've recorded myself to pay back to people in the future, so thank you. Just really briefly to kind of dispel, I suppose, any myths about the differences or similarities between regulated and official searches. I've put this table together, and I will send a copy of it to everybody after the presentation. But what it basically denotes is some really important attributes about the similarities and or differences between a regulated or an official search. Now, I'm just going to draw your attention to some of these sections briefly. First and foremost is the data. The data in a regulated and or an official search is exactly the same, and that is reinforced by EU law. That the council have to provide public access to all data. In fact, CDS actually check additional data sets, for example, Fencer and GasSafe, as the competent person may not always register that information with the council. So it can be often missed off an official search, but we would have picked it up on a regulated search. There's also much more protection for your firm and the client by using a regulated search. So you can see on the screen, we have £20 million of professional indemnity insurance to protect the work that we have done at CDS. But we also have £2 million of council protection for any mistakes that the council make, because every single local authority has a different procedure based on any inaccuracies that they might provide. So we're also insuring you against inaccuracies from the council. But it's important that actually you know that we hold accuracy at the centre of everything that we do. And those insurance policies are actually just a safety net and not an option. Now, I could talk about the screen to you for quite a long time, but I'm conscious today is about VAT and not about searches. So like I said, I will pass this information on after the webinar. But for now, I will pass you back to the professionals. Thank you.
Thank you. And so just to clarify that point and just to confirm that point, what I was trying to illustrate with the tables previously was to confirm that there's a suggestion that you're better off going for the official search because there's no VAT on the official search. Following Brabner's, then it can't be treated as a disbursement, therefore it has to be treated as a as an outlay, which means that VAT will then be charged on top of that official search. So the position remains the same whether it's an official search or whether it's an unregulated search, is that the end cost to the customer will be exactly the same. It may be that the VAT is coming at a different stage in the supply chain, but at the same time, it's as far as the end client is concerned, it's the cost to them that they are physically paying that matters. It doesn't matter how it's arrived at that cost. The fact is, in the scenario that I gave, it will be £1,200 for either cost for a non-VAT registered person. So, if that is chargeable in the service provided by the third party, there's no change for either a VAT registered or an unregistered client. The cost to them will be exactly the same. If VAT is not charged by the third party supplier, the position is unchanged for VAT registered clients because they're able to recover the VAT, but it is changed for unregistered clients because they will suffer an additional 20% cost on that recharge service. But it will put them back in the same position as if VAT had been charged on the original supply. So it doesn't matter which route you go down, the cost will be the same. I hope that makes sense.
Yeah, that does make sense. Thank you very much, Alistair. I'm aware that you can't talk to us, but the public chat is open. So if anybody has any specific questions about what we've been talking about, do feel free to raise them in the chat, or you can send a private chat message to one of us presenters, because we'll have time to answer those questions as we go after we've gone through the other topics. But just to build on one question that I get asked a lot in terms of the VAT is where do we put these in the bills when we raise our bills? And the answer to that is, well, if it's an outlay or a recharge, then it needs to be shown in the same area as your fees are shown. It can be itemized as an individual line, but it still needs to be shown in the fees column, because that's what we're saying it is by calling a recharge or an outlay. If it's a disbursement, and we're following the disbursement treatment, then it belongs in the disbursement column for VAT purposes. Now that might not be consistent with what everybody's been doing for the last 20 years, but it is consistent with HMRC's treatment for VAT purposes. And from an accounts rules perspective, as long as you're itemizing your separate entries out, you are still compliant with the accounts rules as well alongside this. So it just needs, I just thought it was worth highlighting that. So whilst everybody's thinking of questions and sending them in, shall we move on to some other topics that might be relevant? And you can ask questions on these topics as well. And Alistair will talk to us about these.
Yeah, thanks very much. So there's sort of three areas that I was going to mention. The first two have become hot topics largely because of COVID and the restrictions and the move to different ways of working around hybrid working, etc. The last one, just simply because I can't do a VAT session without mentioning Brexit. So that's the reason for the Brexit topic on there. But as we all know, in the last couple of years, the world has changed quite significantly with the way that people have been working, the way that people have been going into their office, etc., which has meant that for a number of reasons, businesses have looked either to vary their leases or terminate their leases and other contracts that they have with suppliers. And certainly in relation to the lease variations, HMRC put out guidance very quickly to confirm that it's basically on a case-by-case basis, but if you are varying a lease and all that you're doing is, for example, changing the term or changing the value of the rental payments and nothing else is happening, there is no other supply being made either by the tenant to the landlord, then there is no VAT consequence of that lease. If it was a taxable lease beforehand, it's a taxable lease afterwards. Where HMRC might get a bit concerned and might look for some additional VAT is where, in order to allow that lease variation, the tenant is agreeing to do something. So it might be, right, we will reduce the rent by 50%, but you will have to do, X, Y, and Z in terms of upkeep of the property. If the tenant is doing something other than just simply paying the rent, then HMRC will see that as being a barter transaction, and the value of that barter transaction is the reduction in the rent. So they're saying that, well, there's supply going both ways. There's a supply for the lease of the building, and there's also supply from the tenant of doing the upkeep works, which weren't their responsibility previously. Therefore, HMRC would be looking for VAT to be going both ways. If it's a taxable lease, then there's not a problem. It's just a case of raising invoices and accounting for that VAT. But if it's an exempt lease from the landlord, but the supply that is deemed, the barter transaction is being deemed to be made by the tenant is a taxable supply, then there would be VAT due on the supply from the tenant to the landlord, which the landlord wouldn't be able to recover because they're making an onward exempt supply. So there's an actual additional VAT cost being generated by that barter transaction. Most times when there's lease variations, it's all that's happening is that there's a rent-free period or there's a reduction in the rent, and there is no barter transaction. But it's something to be aware of and to watch out for, is that if you're assisting clients in negotiating these lease variations, there could be VAT consequences of those. VAT and contract terminations, it's almost as if I planned it, but yesterday HMRC issued their business brief on contract terminations. They had originally issued a business brief in September 2020, which they very quickly withdrew because everyone was disagreeing with the points that HMRC had put forward. So we've been in a bit of limbo since probably about January 21, where we had an idea where HMRC's direction of travel was, but we didn't have final guidance from HMRC. That final guidance has now been issued as of yesterday. So the business brief has come out, setting out what the position is, and HMRC have updated their internal guidance, and that's available for others to see. So the position is now set in stone, and HMRC are expecting businesses to comply with the guidance that's been put out. And the main position is whether or not, if you were agreeing to terminate a contract, was any payment being made in relation to that compensation, or was it payment for the supply under that agreement? HMRC's view very much now is that what you're looking at is payment for the underlying supply. So the fact that, and most of this came out of case law around mobile phone termination payments. So if you, for example, terminate a mobile phone contract, but are required to pay the final payments under that contract, HMRC will just see that as being additional consideration or consideration for that lease contract for that phone. Whereas previously it was seen as being compensation for terminating that agreement early, and it was outside the scope of VAT. That has now been passed into other types of contracts. So whether it's an IT contract, a lease contract for property, if you terminate early, then HMRC no longer see that as being compensation. They see that as payment, additional payment under the terms of the previously agreed contract. If that previously agreed contract was taxable, subject to VAT standard rate, then the the termination payment is also subject to VAT at the standard rate. The main concern we have here is that there will be a lot of agreements written, some of them, 5, 10, 15 years old, where there are terms in there that talk about what will happen in the event of termination. And in those, it's not envisaged that that would be a VAT-able amount. So there might be a mechanism to say how you're going to arrive at that termination payment, but the overall agreement is silent on the VAT treatment of that. If a contract is silent on the agreement of VAT, then it's deemed to be VAT inclusive. Therefore, any termination payment agreed under that agreement is considered to be VAT inclusive. And therefore, it may mean that the person who's terminating pays the same amount, and that might actually get a benefit if they're able to recover that VAT. But the person whose contract has been terminated, who's making the supply, may end up with less money than they expected under the terms of that termination, because they've got to account for 1/6 of that to HMRC. HMRC have said that the position is retrospective, so it does relate to contracts that are already in place. It doesn't just relate to future contracts. It does relate to terminations that are happening from now onwards, rather than termination retrospectively. Originally, when they issued the guidance in September 2020, they said it applied going back 4 years. So people were being asked to look at termination payments they'd made or received in the previous 4 years and recategorizing them, which potentially caused a problem. Dilapidations, originally, again, on the original guidance that HMRC put out, they changed the treatment of dilapidation payments. As we know, dilapidation payments are making good the property and are very much compensation for receiving a property back in less than perfect condition. HMRC now accept that a dilapidation payment is compensation, and they haven't changed their guidance on that. So that position continues. Again, that was only confirmed in the guidance that's come out yesterday. People were in a bit of a limbo for the last 12 months, not sure whether HMRC were going to change the guidance as they originally envisaged, or whether they were going to take on board the views of the industry, etc., who had been saying quite clearly, no, this is compensation. We now know it's compensation, and we don't have to account for VAT on dilapidation payments. And finally, as I said, Brexit, can't have a VAT presentation without Brexit. There have been very, very few changes to the VAT rules as a result of Brexit. And in the sector that we're talking about here, where the place of supply rules for VAT purposes are very much covered by the general place of supply rule. And if it's not covered by the general place of supply rule, then it's covered by where the land is rule. Both of those rules remain the same, and it doesn't matter whether Brexit's happened or Brexit hasn't happened. When you're deciding the place of supply, you're looking at exactly the same rules pre and post Brexit. If it's a general rule service, place of supply is where your customer belongs. So if it's a UK customer, it's going to be subject to UK VAT. If it's a non-UK customer, it's not subject to UK VAT. It's outside the scope of UK VAT. If it's a land-related supply, conveyancing, etc., then the place of supply is where the land is situated. If the land is in the UK, your supply is subject to VAT in the UK. If the land is overseas, similarly, the place of supply is where that land is or where that building is, and it's outside the scope of UK VAT. That is the same regardless of whether Brexit had happened or not. So thankfully, Brexit has not created too much of an issue in this sector. I think there is some questions coming in.
Yeah, we've had one question come in. So let me just go into that question. So the question that's come in is saying, when billing for third-party conveyancing searches, we claim the input VAT and recharge the output VAT to the client. Our accounting software handles this as an office payment, and when paying the third-party supplier and puts 20% input tax into our VAT account, and when added to a client's bill, it is itemised individually, but is identified as an additional charge with output VAT, and it's not shown as a disbursement. Is this acceptable?
Yes, that's following both the principles and the guidance from Bramner's and the Law Society guidance is suggesting that's the treatment. So yes, more than acceptable. That is 100% the correct way to deal with that.
That's it. So we're following the recharge or outlay model there, and we are presuming that you are advising on the searches rather than just literally collecting and postboxing them out, and so that is the correct treatment. Are there any other questions that?
Yeah, another one's come in there. Run over the position on court fees again. So again, court fees are an official fee. If all that you're doing is, again, acting a bit like a post box, and either the client's filled in the forms or you're just very basically filling in the forms, i.e. putting in the client's name, address, etc., then you could argue that that is a disbursement. You're not adding any value to that by undertaking that. However, if it's quite clear that in submitting the court fees, either because there's a section in the box on the form, or that it's quite clearly forming part of the overall supply that's being made. You know, so for example, there's a skeleton argument, or there's a statement of case or something like that that's attached to those fees, and therefore what you're doing is adding value to the service and it's part of your overall service, then that would fall to be an outlay rather than disbursement. So if you're acting as a postbox, disbursement. If you're adding value and doing more than just simply paying the court fees, then that would be seen as being an outlay.
Alistair, would we be willing to stick our neck out and say that the default position would be that a court fee would be a disbursement unless we are actively providing advice on it, or would it be the other way round?
I would say that, particularly following BA Prosser, where the judge in that case said that there would be very few examples where a legal firm is acting purely as a post box, then they would take the view. I would take the view, following on from BA Prosser, that the default would be it's an outlay rather than the default being it's a disbursement. And again, as we said, it's very much proving that it's a disbursement and treating as an outlay and within the scope of VAT, unless you can prove it's a disbursement.
Okay. There's another question just around, is there a document with this guidance and advice that we can send around? We'll be sending around a copy of the slides that everybody can have and refer back to. And if you need more specific guidance than that, then we haven't got to it yet, but the last slide does contain contact details for all three of us in relation to, and so you can follow up with us on any specific points that you would like to follow up on. I haven't seen any further questions. I'm just checking I've not missed any. No, in that case, this is we'll conclude in a moment. This is the first of a series of webinars that are being supported by the Leeds Law Society. So just keep your eye open on the Legal Law Society website and so on for further webinars. They're not all on VAT. I'll just say that. There are other topics coming as well. So just keep your eye out for that. And I'm going to hand back to Rebecca just to finish off for us.
Yeah, thank you. Just to add, so I will send everybody an email kind of after the webinar with a copy of the slides, and I will include Joel and Alistair's contact details. So whether it's now or in the future, you know, if you do have any tax-related questions, I will most definitely direct them to them for you. If you have any search-related questions, I'd be more than happy to assist. And I've just put some basic pricing on the screen, should anybody be interested. Just some housekeeping here for the guys at Sagars, that's included there. And then finally is our contact details. So I'd just like to say a massive thank you to Joel and Alistair for presenting today. It's a common subject that I come across with clients, which is the VAT on disbursements, and it didn't feel like we'd had any webinars on this recently. So thank you very much for putting this together, gents. And I will send everything out to all those that came and joined us today. Thank you very much, everybody.
Thank you very much for listening, everybody.
Yeah, thank you. Bye-bye.
Right, thank you very much.
Right.